You don't belong here!
She didn't do anything!
Remember my face. Why, who are you? You're...
Cassidy Vance yanked the coffee cup out of the woman's hand and threw it. Not dropped it. Not set it down. Threw it. The cup hit the concrete floor of the parking garage on level 3 of the Meridian Grand Hotel, and the sound cracked through the air like a gunshot. Dark coffee splattered across the woman's gray coat, across her shoes, across the side of her Honda Civic. Cassidy stepped closer. Her voice didn't rise. It didn't need to. Let me be very clear with you. This is not a place for a broke black girl to be wandering around touching things that don't belong to her. You want to stand next to a nice car so bad, go stand on the curb outside. That's where people like you belong, not in here. The woman opened her mouth slightly. Cassidy cut her off before a single word came out. Don't explain yourself to me. I don't want to hear whatever excuse comes out of your mouth. You people always have an excuse, don't you? Always a reason why you're somewhere you shouldn't be. She turned toward the valet, a young man named Tommy, who had gone completely still, and pointed at the woman like she was a piece of misplaced furniture. Why is she still standing here? Is this how this hotel operates now? You let just anyone walk in off the street. She looks like she slept in that coat. Get her out of here before I call management, or should I just call the police and let them sort out what a homeless black woman is doing alone on level 3? Tommy didn't move. He couldn't. The two women near the elevator had stopped pretending not to watch, and the woman in the gray coat, coffee still dripping from her sleeve keys, still in her hand. The small dent on her Honda Civic catching the garage light behind her said absolutely nothing. She looked at Cassidy Vance with an expression so still, so completely undisturbed, that it was almost frightening. Cassidy mistook that stillness for defeat. She had no idea she was screaming at a federal judge. She had no idea that in 4 days that same woman would walk into a courtroom, wearing a robe, pick up a gavel, and sit in the highest chair in the room, directly above Cassidy Vance, and everything her father had spent 30 years building. Stay with me, because what happens inside that courtroom will leave you without words. Drop a comment and tell me where you're watching from and what time it is there right now. Someone sitting near you might be watching this exact story at this exact moment. And if you haven't subscribed yet, do it now. This is not a story you want to walk into halfway. Welcome back. Friends, I've spent years crossing this country, collecting stories that hit straight in the heart. Take a chair. The federal courthouse on Spring Street in downtown Atlanta did not look like a place where lives changed. It looked like what it was, a gray stone building with wide steps and heavy doors and a security checkpoint that smelled like burnt coffee and floor wax. People moved through it every day, carrying folders and briefcases and expressions that said they had been here before and would be here again. It was a building designed to feel permanent, unmovable, larger than any single person who walked through its doors. Zara Mitchell had walked through those doors every morning for 3 weeks. She still felt it every time. A small tightening in her chest just for a second, just at the threshold, and then it passed, and she was inside, and she was working. She was 34 years old. She had been appointed to the federal bench 11 weeks ago, one of the youngest federal judges in the history of the Northern District of Georgia. The appointment had come after 6 years as an assistant U.S. attorney, 2 published law review articles on housing discrimination, and a recommendation from Judge Harold Fenwick that he later described in a private letter as the easiest he had ever written. None of that made the building feel smaller. Her office was on the 4th floor. Small by federal standards, a desk, 2 chairs for visitors, a bookshelf that was already overfull, a window that looked out over a parking structure. On the desk was a photograph of her mother Sandra standing in front of their old house on Glenwood Avenue, squinting into the sun, smiling the way she smiled when she didn't know anyone was watching. Her robe hung on a hook behind the door. It still had the dry cleaning tag clipped to the collar. She hadn't removed it yet. She wasn't sure why. It felt in some way she hadn't examined too closely, like a thing she needed to earn one more time before she wore it in front of people. She ate lunch at her desk. She took the bus on Tuesdays and Thursdays when the weather was good. She drove the Honda on the other days, the one with the small dent above the rear wheel that she kept meaning to fix and never did. She was not what people expected when they looked at her in the hallway. She knew that. She had known it her whole life. She had learned a long time ago to let the surprise work in her favor. The case file for Reyes versus Vance Meridian Group landed on her desk on a Wednesday morning, sandwiched between a securities fraud motion and a request for continuance in a tax case. It was a civil matter, wrongful termination, hostile work environment, documented racial harassment. The plaintiff was Dana Reyes, 29 years old, former logistics coordinator. The defendant was Vance Meridian Group, one of the largest privately held development and logistics companies in Georgia, with annual revenues the filing listed at just over $800 million. Zara opened the file and read for 40 minutes without stopping. Dana Reyes had worked at Vance Meridian for 2 years and 3 months. In that time, according to the complaint, she had been told by her direct supervisor that her accent made her sound unprofessional. She had been passed over for 2 promotions that went to colleagues with fewer qualifications and shorter tenures. She had been excluded from team meetings, had her work reassigned without explanation, and had been referred to in a department group chat, documented screenshot attached as Exhibit C as the diversity hire who can't find the bathroom. Her direct supervisor's name was Cassidy Vance. Zara read that name and was quiet for a moment. Then she kept reading. Dana had filed an internal HR complaint 14 months into her employment. The complaint was thorough, dated entries, names, specific incidents, screenshots. The kind of documentation that said this person had been paying attention from the beginning, had known she might need it, had been quietly building a record the way someone builds a wall against a flood they can already see coming. The HR complaint had been received, logged, and buried. The HR director at the time of the filing was a woman named Patricia Holloway. A note in Dana's personnel file written 6 weeks after the complaint was submitted described the complaint as reviewed and resolved with no findings of policy violation. Patricia Holloway had been Cassidy Vance's college roommate at Emory. 3 months after the HR complaint was closed, Dana Reyes was terminated. The termination letter cited performance concerns and failure to meet departmental expectations. Her most recent performance review, conducted 2 months earlier, had rated her as meets all expectations in every category. Zara set the file down. She looked at the window, at the parking structure outside, at the gray Atlanta sky above it. She thought about the parking garage, about the coffee hitting the floor, about Cassidy Vance's voice, not loud, not hysterical, just certain. The certainty of someone who had never once been told that the way she spoke to people had consequences. Zara picked up the file again. She had every reason to recuse herself. A reasonable argument could be made. A personal encounter with the defendant, even one where Zara had said nothing, done nothing, simply stood and absorbed, could be characterized by the right attorney as grounds for reassignment. She sat with that thought for a long time. Then she placed the file in the center of her desk, opened her calendar, and scheduled the preliminary hearing. She was certain she could be fair. She had been certain of harder things, and that certainty, quiet, absolute, tested by everything her life had already handed her, was precisely the most dangerous thing about Zara Mitchell. Dana Reyes had a way of sitting very still when she talked about it. Not stiff, not the stillness of someone holding themselves together by force. Something different. The stillness of someone who had already cried every tear available to them on the subject, and had arrived on the other side of that at something quieter and harder and more durable than grief. She sat across from her attorney, Marcus Holt, in a small conference room on the 3rd floor of the courthouse. Her hands folded on the table, a glass of water in front of her that she hadn't touched. Marcus Holt was 29 years old, 3 years out of Georgia state law, and this was the largest case he had ever handled. He knew it. His client knew it. The legal pad in front of him had more crossed-out sentences than complete ones, and he had a habit of clicking his pen that he wasn't aware of until someone pointed it out. Donna had pointed it out 20 minutes into their first meeting. He hadn't clicked it since. "Tell me again about the group chat," Marcus said. "The one with Exhibit C." Dana looked at the table. It started about 4 months in. There was a department group chat for logistics updates, scheduling, that kind of thing. Someone added me late. When I scrolled up to read the history, I found it. The comment about the diversity hire. That was one of them. She paused. There were others. Someone asked who had taken the last of the coffee in the break room, and Cassidy wrote back, quote, "Probably Dana, she takes everything that isn't hers." Dana's voice didn't change. "I had not taken the coffee. I don't drink coffee." Marcus wrote something on his pad. "There was another one," Dana continued. "A week before I was fired, someone in the group shared a photo from a team lunch I hadn't been invited to." Cassidy commented, "And I'm reading this exactly, finally, a picture where everyone actually belongs here." The conference room was very quiet. "I saved all of it," Dana said. "Every message, every date. I emailed them to my personal account the night I found them. I didn't know if it would matter. I just knew I needed to have them somewhere that wasn't their server." Marcus looked at her. "You were thinking like a lawyer before you had one." Dana gave a small, tired smile. "I was thinking like someone who knew no one was going to believe her without proof." Marcus had requested a brief chambers meeting with Judge Mitchell before the preliminary hearing, standard procedure, an opportunity to flag procedural questions before both sides were in the room. He arrived 5 minutes early, which was the first time in his career he had arrived anywhere 5 minutes early. Zara came in from the side door, still in her regular clothes, black slacks, white shirt, reading glasses pushed up on her head. She shook his hand, sat down, and opened the file. "I've read the complaint," she said. "I've read the defendant's initial response. I have questions about the HR documentation timeline." She looked at him directly. "Is your client prepared to testify?" "Yes, Your Honor." "Is the HR director, Patricia Holloway, going to be available as a witness?" Marcus hesitated. "She left Vance Meridian 8 months ago. We're still attempting to locate her current employer." Zara wrote something. "Keep attempting." She closed the file and looked at him again. Not unkindly, but directly, the way someone looks at you when they want you to understand that the usual performances won't be necessary. "Mr. Holt," she said, "your client documented 2 years of her professional life in extraordinary detail. That documentation is your foundation. Build on the foundation. Don't embellish it." "Yes, Your Honor, and don't be late." He wasn't. The same afternoon, in a building 14 blocks away, Leonard Marsh sat in a corner office on the 31st floor of a glass tower and filed a motion to dismiss. Leonard Marsh was 56 years old, a senior partner at Caldwell Marsh and Associates, and he had been winning cases for powerful people in Atlanta for 27 years. He did not raise his voice in courtrooms. He did not need to. He moved through legal proceedings the way a very large, very patient animal moves through tall grass, slowly, deliberately, certain that eventually something smaller would stop running. The motion cited procedural grounds, questioned venue, raised in language that was careful enough to be technically unprovable, a subtle implication about the assigned judge's qualifications and impartiality. He had filed variations of this same motion 11 times in the past 4 years. 9 of those 11 judges had been black or female. His assistant brought him coffee while he reviewed the final draft. He made 2 small edits, initialed the bottom of the last page, and handed it back without looking up. "File it today," he said. She filed it at 4:47 p.m. Zara received the copy at 5:12 p.m. She was still at her desk. The building was mostly quiet by then, just the hum of the HVAC system and the faint sound of traffic on Spring Street below. She read the motion once. Then she set it to the side of her desk. Not in the file, not in the trash. Just to the side where she could see it. Then she reached into her desk drawer and took out a single photograph. Dana Reyes at her desk, smiling, unaware of the camera. A woman who had documented 2 years of her life because she already knew no one would believe her without proof. Zara looked at the photograph for a long moment. Then she went back to work. Richard Vance learned who the judge was on a Thursday morning. He was in his office on the 41st floor of the Vance Meridian Tower when his assistant, a precise and efficient man named Colin Draper, set a single sheet of paper on his desk. It was a printed profile public record courthouse website with a photograph clipped to the top right corner. Richard looked at the photograph. He looked at it for longer than he usually looked at anything. Then Colin said quietly, "There's something else, sir." He placed a second sheet on top of the first, a printed still image from a hotel security camera. Level 3 of the Meridian Grand parking garage. Timestamp Tuesday, 7th. 14 p. Cassidy mid-gesture. The woman in the gray coat. The coffee on the floor. Richard Vance did not move for a full 10 seconds. Then he said, "Get Leonard on the phone." Colin had Leonard Marsh on the line in 4 minutes. Leonard listened to Richard without interrupting. That was one of the things Richard paid him for, the ability to absorb bad information without making noise about it. When Richard finished, Leonard said, "The motion to dismiss is already filed. The recusal argument is in there, framed procedurally." "Will it work?" A pause. "It should create enough friction to slow things down. But if she's sharp..." "She is," Richard said. He was still looking at the photograph. "Find something else." 2 days later, Leonard Marsh had lunch with Judge Harold Fenwick at a restaurant in Buckhead they had both been going to for 15 years. White tablecloths, low lighting, the kind of place where important conversations happened in quiet voices over grilled fish. They talked about the Braves for 12 minutes. Then Leonard set down his fork. "Harold," he said, "I want to ask you something as a friend." Fenwick looked at him. "This Mitchell appointment. She's very new, very green. For a case of this complexity, this financial scale, is it appropriate? Is it fair to her even to put her in the middle of something like this so early?" Fenwick picked up his water glass. He did not drink from it. He just held it. "She clerked for the 11th Circuit, Fenwick said. She tried 41 cases as an AUSA. She published 2 pieces on housing discrimination law that are currently cited in 3 active federal circuits." He set the glass down. "She's not green, Leonard. She's just young. Those aren't the same thing." Leonard smiled pleasantly. "Of course. I only mean..." "I know what you mean," Fenwick said. His voice was still calm, still friendly, but something in it had shifted the way temperature shifts in a room when someone opens a window in winter. "And I want you to hear me when I tell you as a friend that whatever you're thinking about doing, you should think about it very carefully. Leonard said nothing. They finished lunch talking about the Braves. That evening, Fenwick called Zara at home. "Someone's making noise," he said without preamble. "I won't tell you who or what was said because I don't think it would help you to know. What I will tell you is be ready. Not just prepared. Ready." Zara said, "I understand." After she hung up, she sat at her kitchen table for a long time. The charity gala was at the Biltmore on Friday night. Cassidy Vance arrived at 8, in a deep emerald dress, her hair up 2 glasses of champagne, into the evening before the main course was served. She was at a table with 4 people she knew, and 2 she didn't. One of the 2 she didn't know was a woman named Claire Ashby, 38, quiet, a press badge tucked into her clutch that she hadn't mentioned. Claire freelanced for 3 publications and had been working on a piece about Atlanta's corporate class for 11 months. Claire was very good at being someone people talked in front of. Cassidy leaned toward the woman to her left and said at a volume that was meant to be private but wasn't, "Did you hear about this lawsuit? The one against my father's company?" The woman nodded sympathetically. "Can you believe they assigned it to some affirmative action judge who's been on the bench for 5 minutes? She probably got her degree online. Daddy's lawyers are going to eat her alive." She laughed a short, bright, effortless laugh. "It's almost not fair." Claire Ashby wrote 4 words on the small notepad in her clutch. She said, "Affirmative action." The leak appeared on a local legal blog the following Monday morning. It was a short post, 4 paragraphs that raised questions about Zara's law school admission record, framed carefully as questions being asked in legal circles about whether certain appointments reflected merit or institutional pressure. The post did not name sources. It did not need to. The implication was its own argument. Zara read it at her desk at 7:40 a.m., 1 full read. Then she closed the laptop. She picked up her phone and called Brianna Cole, her oldest friend, a social worker in Decatur, the person who had known her since the 7th grade, who had watched her study for the bar exam at a fold-out table in a studio apartment with no air conditioning in July. "Did you see it?" Brianna asked immediately. "Yes. You okay?" "I'm fine." Zara. A long pause. Outside her window, the parking structure was filling up slowly in the early morning light. "I'm scared," Zara said quietly. Not ashamed of it. Just honest. "Good," Brianna said. "That means you know exactly what you're fighting for." Zara nodded, even though Brianna couldn't see her. What neither of them knew, yet what Zara would not discover until the following morning, was that the leak had not come from a stranger. The device that had accessed and forwarded her law school records had been traced quietly by a courthouse IT administrator who had flagged it without being asked. It was registered to a firm. The firm was Caldwell Marsh and Associates. Detective Ray Okafor had a wall in his office, not a whiteboard, not a corkboard. An actual wall, the one facing his desk in the small, windowless room he occupied, on the 2nd floor of the Atlanta Financial Crimes Unit. Over 14 months, that wall had accumulated a map of something that looked from a distance like a spider's web. Names connected by string dates circled in red marker, photocopies of city contracts pinned in overlapping layers until the original paint underneath was almost invisible. The name at the center of the web was Vance Meridian Group. Ray had been a detective for 16 years. He had worked narcotics, then homicide, then financial crimes, a path that surprised people until he explained it. Drug money and murder money look different on the street, he would say. On paper, they look exactly the same. He was 43 years old, methodical in a way that some colleagues mistook for slowness and others recognized as precision. He did not rush conclusions. He built them the way a structural engineer builds a bridge, load-bearing point by load-bearing point, nothing added, until the previous layer was certain. The Vance Meridian investigation had started with a single anomaly. 14 months ago, a city auditor named Gregory Fells had flagged a discrepancy in a road infrastructure contract awarded to Vance Meridian's logistics subsidiary. The contract was for $4.2 million. The completed work, when inspected, corresponded to approximately $2.7 million in actual labor and materials. The difference, $1.5 million, had been billed, approved, and paid. Gregory Fells had submitted his flag through the standard internal channel. 3 weeks later, he had been reassigned to a different department. The flag had not been formally investigated. Ray had found it by accident buried in a database query he was running on a separate matter. He had printed it out, stared at it for a long time, and then quietly begun pulling every Vance Meridian city contract from the past 6 years. There were 31 contracts total. Combined value $34 million. Of those 31, Ray had identified 9 with billing irregularities significant enough to warrant investigation. Overbilling. Work completed at lower specifications than contracted. In 2 cases, work listed as completed that showed no evidence of ever having been started. The approvals on those 9 contracts all carried the signature of one of 2 city officials, Councilman Derek Paulson or Deputy Infrastructure Director Warren Lyle. Both men had received campaign donations from entities connected to Vance Meridian in the same fiscal years the contracts were awarded. Ray had not yet moved on any of it. He was still building, still making the bridge load-bearing before he added weight. Then, on a Tuesday morning, he noticed the civil lawsuit. Reyes v. Vance Meridian Group. He read the complaint in 40 minutes. When he reached the section describing Dana's termination, he slowed down. Donna Reyes had been fired 2 weeks after filing an internal HR complaint. That detail Ray already knew. It was in the complaint. But there was a second detail buried in a footnote in the supporting documentation that stopped him completely. 2 weeks before Dana was fired, she had accessed a shared internal drive folder labeled City Contracts Infrastructure Q3. The access log showed she had opened 6 documents in that folder over 2 days. The log also showed that those 6 documents had been deleted from the server 4 days after Dana's termination. Ray sat back in his chair. He pulled up his own files, his 9 flagged contracts. He cross-referenced the dates. 3 of the 9 irregularities he had flagged corresponded directly to the Q3 infrastructure cycle. The same cycle Dana had accessed. The same documents that were deleted after she was fired. Dana Reyes had not been fired for performance issues. She had not even been fired primarily for complaining about Cassidy Vance. She had been fired because she had accidentally opened a door that someone very powerful needed to stay closed. Ray picked up his phone and called Marcus Holt. They met at a coffee shop in Decatur, away from downtown, away from the courthouse. Marcus arrived looking like a man who had not slept well, which was accurate. Ray arrived looking like a man who had, which was also accurate. He ordered black coffee and set a thin folder on the table between them. "I'm not here officially," Ray said. "This conversation didn't happen. What I'm about to show you is public record city contracts, public financial disclosures. Nothing that required a warrant." Marcus opened the folder slowly. Ray talked him through it. The contracts, the billing irregularities, the campaign donations, the access log, the deleted files. Marcus read in silence. His pen was still for the first time in memory. When Ray finished, Marcus looked up. "She found the fraud files." "She didn't know what she was looking at," Ray said. "But someone knew she'd seen them." So Marcus sat back. "This changes the entire case." "Your case, yes," Ray said. "Mine too, if she still has what she copied." Marcus looked at him. "She does," he said quietly. "She emailed everything to herself the night she found it. I have it in discovery. I didn't fully understand what I was looking at until right now." Ray nodded slowly. Then we should talk to your judge. Marcus hesitated. She's already under pressure. There's been a leak about her record, a motion to recuse. I know, Ray said. I've been watching this case. He wrapped both hands around his coffee cup. Outside, the morning traffic on Church Street moved steadily past the window, ordinary people going to ordinary places, unaware that 14 blocks away, in a building with heavy doors and a security checkpoint, a woman was quietly building a case that was about to become something much larger than either of them had expected. She found the pattern, Ray said. She just wrote it on a legal pad. I've had it on a wall for 14 months. He looked at Marcus directly. It's time to connect them. The morning of the preliminary hearing, Tommy Reeves woke up at 5:15 a.m. He was not scheduled to work until noon. He lay in bed for a few minutes, staring at the ceiling of his apartment on Flat Shoals Avenue, then got up, showered, put on the cleanest shirt he owned, and took the number 12 bus downtown. He had seen the case mentioned on the local news 2 nights ago. A photograph of the federal courthouse. A reporter saying the words, Vance Meridian and wrongful termination and preliminary hearing Thursday morning. Tommy had stood in his kitchen watching that report with a glass of water in his hand and had not moved until the segment ended. He knew the judge's name now. He had looked it up. He did not tell anyone where he was going. He just went. Courtroom 7C was on the 4th floor, and by 8:40 a.m. it was already filling. It was not a large courtroom. Federal preliminary hearings rarely drew crowds, but word had traveled in the way that word travels in legal communities, quietly from clerk to clerk, from hallway conversation to hallway conversation, until the gallery held not just the standard observers, but junior attorneys who had rearranged their morning schedules. 2 reporters with notepads, and a row of people from the West Side Neighborhood Association who had come in their good clothes and were sitting very straight. Tommy found a seat in the 3rd row on the left side. He folded his hands in his lap and waited. At 8:55, Leonard Marsh entered with 2 associates and Cassidy Vance. Cassidy was dressed impeccably, charcoal suit hair, back the composed expression of someone who had been told by every person around her that this was a formality, a nuisance, something that would be handled before lunch. She walked to the plaintiff's table and sat down without looking at the gallery. Marcus Holt was already seated at the defense table, his legal pad open, his pen still. Dana Reyes sat beside him, hands folded, that particular stillness about her that had nothing to do with weakness. At 9:00 exactly, the bailiff stood. All rise. Everyone stood. The door beside the bench opened. Zara Mitchell walked in. She was wearing the robe. The dry cleaning tag was gone. She moved to the bench with the same unhurried steadiness. She moved everywhere, pulled out her chair, sat, and looked out over the courtroom. Her reading glasses were on. A file was open in front of her. She did not look immediately at the plaintiff's table, but Cassidy Vance looked at her. The recognition happened in stages. First a slight narrowing of the eyes, then a very small tilt of the head, then the moment visible to anyone watching closely enough when it landed completely. The parking garage, the gray coat, the coffee on the floor, the woman she had called homeless, sitting above her. Cassidy leaned 6 inches to her left and whispered something into Leonard Marsh's ear. Marsh's expression did not change. He nodded once, almost imperceptibly, and placed his hand flat on the table in a gesture that said, I know. I have it. Zara looked up from her file. She let her gaze move across the courtroom, the gallery, the attorneys, the parties, in the way that experienced judges do, not searching for anything, simply establishing presence. When her eyes crossed the plaintiff's table, she paused for exactly 1 second. Then she looked at her file. Good morning, she said. We are here for the preliminary hearing in Reyes First Vance Meridian Group. Before we begin, are there any preliminary motions? Leonard Marsh stood immediately. Yes, Your Honor. The defendant moves for recusal of the presiding judge on grounds of personal conflict with the defendant. The room shifted. Not loudly, a subtle collective adjustment, the way a room adjusts when the temperature changes suddenly. Zara looked at him. Grounds, Mr. Marsh. Marsh reached into a folder and removed a photograph. He handed it to the bailiff, who brought it to the bench. Your Honor, the defense submits that the presiding judge has had a prior personal interaction with the defendant, Cassidy Vance, of a nature that may reasonably give rise to the appearance of bias. He paused, letting the implication breathe. We have obtained security footage from the Meridian Grand Hotel parking facility, dated 4 days ago, showing the judge and Ms. Vance in a direct personal confrontation. Given the emotional nature of that interaction, and given that this case involves Ms. Vance as a named party, we submit that reassignment is the appropriate course. Several people in the gallery exchanged glances. Donna Reyes looked straight ahead. Tommy in the third row felt his jaw tighten. Zara looked at the photograph. She looked at it for a long moment. The garage, the coat, the coffee on the floor, Cassidy's extended finger pointing at her like a piece of furniture. She set the photograph down. Mr. Marsh, she said. Her voice was level, completely level. You have submitted as evidence of my potential bias a security photograph documenting your client verbally abusing a stranger in a parking garage. She paused. You have not submitted evidence of any improper statement or action on my part during that interaction, because there was none. Another pause, shorter. You have submitted evidence of your client's conduct. Not mine. The courtroom was absolutely silent. The motion for recusal is denied. She looked back at her file. Let's proceed. Cassidy Vance's face had gone the color of paper. Beside her, Leonard Marsh sat down with the careful, deliberate movement of a man recalibrating. In the third row, Tommy unfolded his hands. And in the gallery near the back, a woman with a press badge in her clutch wrote 3 words in her notepad. She didn't flinch. Marcus Holt had prepared his opening statement 6 times. He had written the first version the week Dana came to him. He had rewritten it after reading Leonard Marsh's motion to dismiss. He had rewritten it again after the preliminary hearing was scheduled, and twice more after his coffee shop meeting with Ray Okafor. The 6th version, the one he had on the legal pad in front of him now, was the shortest. 41 sentences. He had counted them. He stood up and delivered it in 8 minutes. He did not embellish. He did not perform. He laid the foundation the way Zara had told him to, the documentation, the timeline, the HR complaint, the termination letter, and he let the facts carry the weight, because the facts were heavy enough. When he sat down, the courtroom was quiet in a way that felt different from before. Less uncertain. More focused. Leonard Marsh's opening was 22 minutes. It was polished, confident, and built on a single argument that Dana Reyes had been a consistently underperforming employee whose termination was a legitimate business decision, that the HR complaint had been properly reviewed and found without merit, and that the lawsuit was a financially motivated attempt to extract a settlement from a successful company by exploiting the current cultural climate. He said the phrase current cultural climate twice. Zara wrote something on her notepad. She did not look up. Dana Reyes took the stand at 10:17 a.m. She was sworn in, sat down, and folded her hands in her lap, that same stillness, that same quality of having already decided she would not be made to feel small in this room. Marcus walked her through the first 14 months, methodically. The comments about her accent, the excluded meetings, the group chat. The performance review that rated her competent, followed 9 weeks later by a termination letter citing incompetence. He introduced each exhibit, slowly gave the courtroom time to absorb it and asked Dana to read key passages aloud in her own voice. She read them clearly, without visible emotion, without performance. That restraint, Zara noticed, was doing more work than any display of feeling could have. A woman who had cried would have been called dramatic. A woman who read the words, "Diversity hire who can't find the bathroom," in a steady voice and then looked calmly at the attorney, asking the next question that was something harder to dismiss. Leonard Marsh objected 14 times in the first hour. Zara overruled 11 of them, citing specific precedent each time. The other 3 she sustained, briefly explaining her reasoning before moving on. A court reporter in her 3rd decade of service would say afterward to a colleague over lunch that she had never heard a judge cite case law from memory with that kind of speed and accuracy. "She didn't look anything up," the reporter said. "Not once." At 11:40, Marcus shifted. "Ms. Reyes," he said, "I want to direct your attention to the 2 weeks preceding your termination, specifically to a folder you accessed on the Vance Meridian shared internal drive." Leonard Marsh was on his feet before the sentence was finished. "Objection. Relevance." "Your Honor," Marcus said, "the plaintiff's access to this folder and the subsequent deletion of its contents is directly material to the circumstances of her termination." Zara looked at Marsh. "I'll allow it." Overruled. Marsh sat down slowly. Marcus turned back to Dana. "Can you describe what you found in that folder?" Dana took a breath, the first visible one since she had taken the stand. It was labeled City Contracts Infrastructure Q3. I opened it by mistake. I was looking for a logistics scheduling file, and I clicked the wrong folder. "What did you see?" "Contract documents, billing summaries, approval signatures." She paused. "I'm not an accountant. I don't have a finance background. But I had been doing logistics coordination for 2 years, and I knew what contract documentation was supposed to look like. Some of what I saw didn't look right." "In what way?" "Numbers that didn't match. Line items billed at amounts that seemed inflated. Work described as completed in phases that I knew from my own scheduling records hadn't been started yet." The courtroom had gone very still. "What did you do?" Marcus asked. "I copied the documents to my personal email. I didn't know what to do with them. I just knew I needed to have them somewhere that wasn't their server." She looked directly at Marcus. 4 days later, I got a call from HR saying my performance review had been escalated and there would be a formal meeting. 2 weeks after that, I was terminated. Marcus reached into his folder. "Your Honor, the defense moves to introduce Exhibit G, a server access log from Vance Meridian's internal system, obtained through discovery documenting Ms. Reyes's access to the infrastructure folder and a subsequent deletion log showing those same documents were removed from the server 4 days after her termination." Marsh stood. "Objection. Foundation. The access logs were produced by the defendant in discovery, Your Honor," Marcus said. "Their own records." Zara looked at Marsh. "Overruled. Exhibit G is admitted." She looked at the documents Marcus placed before her. The dates, the access timestamps, the deletion record. Her expression gave nothing away. But under the bench, her pen had stopped moving, because the deletion date on those files was the same date Dana's termination letter had been generated. Not 2 weeks later. Not a month later. The same day. Someone had fired Dana Reyes and erased the evidence on the same morning. Marcus turned toward the gallery for just a moment. Ray Okafor was seated in the second row, a sealed envelope on his knee, his face calm and completely unreadable. He gave Marcus the smallest nod. Marcus turned back to the bench. "Your Honor," he said. "The defense has one more witness to call." Richard Vance watched the hearing on a laptop. His assistant Colin had set up a secure feed from a paralegal inside the courtroom, a second-year associate from Marsh's firm, who sat in the gallery with a phone angled just enough to capture the audio. It was not legal. Richard Vance had stopped asking whether things were legal approximately 20 years ago. He asked instead whether they were traceable, and Colin always had the same answer: not to you. Richard sat at his desk on the 41st floor and watched Dana Reyes read the group chat messages in her steady, unbroken voice. He watched Leonard Marsh object 14 times. He watched the judge overrule 11 of them without hesitation, without notes, without a single moment of visible uncertainty. He watched the access log go into evidence. When the screen showed the deletion date the same morning as the termination letter, Richard closed the laptop. He sat very still for a long moment. Outside his floor-to-ceiling windows, Atlanta spread in every direction, the way it always had, the way it had spread beneath him for 30 years. Buildings he had helped finance. Roads built on contracts his company had won. A skyline that had his fingerprints on it in places no one would ever think to look. He picked up his phone and called Councilman Derek Paulson. Paulson answered on the second ring, which meant he had been waiting. "I just watched the access log go into evidence," Richard said. A long pause on the other end. Then, "How bad is it?" "The deletion date matches the termination date exactly. If someone connects the fraud investigation to the civil case, no one's connected them yet." "Yet," Richard said. The words sat there. Another pause. "What do you need?" Richard stood and walked to the window. "I need this case moved, reassigned. I need that judge off this docket before the end of the week." "Richard," Paulson's voice dropped. "She's a federal judge. I can't touch a federal judge." "You approved 9 contracts that overbilled the city by $11 million, Richard said quietly. "You can touch whatever I need you to touch." The line was silent for several seconds. "I'll make a call," Paulson said finally. "I can't promise anything." "Make the call," Richard said, and hung up. The formal complaint against Zara Mitchell was filed with the 11th Circuit Judicial Conduct Committee at 2:15 that afternoon. It was 4 pages. Anonymous. It alleged that Judge Mitchell had demonstrated a pattern of bias against corporate defendants, had made extrajudicial statements about the Vance Meridian case to a third party, and had failed to disclose a prior personal interaction with a named party that constituted a conflict of interest. Every allegation was either unprovable, unverifiable, or false. But it existed, and its existence would create a record, a notification, a process that took time even when the outcome was inevitable. That was the point. Not to win, to slow. The complaint landed on Judge Fenwick's desk at 3:40 p.m. He read it in 7 minutes. He picked up the phone and called the committee's chief administrator. "How long for review?" he asked. "Standard timeline 4 to 6 weeks. Expedited tokuntra," a pause. 48 to 72 hours if there's sufficient cause. "There's sufficient cause," Fenwick said. "Review it tonight." He hung up, sat back, and looked at the ceiling for a moment. Then he called Zara. "There's a conduct complaint," he said. "Anonymous. I want you to hear it from me first." Zara was at her kitchen table. Sandra was sitting across from her, eating quietly, not asking questions the way Sandra Mitchell had always understood when questions were not what her daughter needed. "All right," Zara said. "It's thin," Fenwick said. "Very thin. I've requested expedited review. You'll have an answer before the next hearing date." "Thank you, Harold." "Don't thank me. Just keep doing what you're doing." A pause. You cited Ash vs. Tyson Foods from memory this morning. In the correct context. I heard about it from 3 different people by noon. Zara almost smiled. Good night, Harold. She set the phone down. Sandra looked at her across the table. She did not ask what the call was about. She had raised Zara in a house where certain things were understood without being spoken, that hard work was not a guarantee, that dignity was not negotiable, and that people who felt threatened by your competence would always find a way to say it was something else. You eat anything today? Sandra asked. Lunch at my desk. Sandra stood, moved to the stove, and started heating something without being asked. Cassidy's interview posted at 11:01 that night. It was a podcast local, moderately followed, the kind of platform that existed in the space between journalism and conversation. Cassidy had agreed to it through an intermediary, described as an opportunity to share her perspective on what she called a politically motivated lawsuit. She was composed throughout, measured. She chose her words carefully enough that nothing she said was technically actionable. But near the end, the host asked how she felt about the judge assigned to the case. Cassidy paused for exactly the right length of time. I don't know Judge Mitchell personally, she said. I think it's just interesting that someone with her background, her particular path to the bench, would be assigned to a case involving people like us. She gave a small, careful laugh. But I have full confidence in the legal system. People like us. The clip was 47 seconds long. By midnight, it had been shared 900 times. By 3:00 a.m., it had been shared 11,000 times. Claire Ashby, who had been at the charity gala, who had written 4 words in her notepad 3 weeks ago, was awake at her desk when the clip crossed her feed. She opened a new document, looked at her 11 months of notes, and began writing the piece she had been building toward for almost a year. She typed the title first. The People Who Get Away With It. Then she started from the beginning. The second hearing was on a Friday. By 8:00 a.m., there were news cameras on the steps outside the federal courthouse on Spring Street. Not local news, only a national outlet had picked up the story Thursday evening, 40 minutes after Claire Ashby's piece went live. The piece had gone further and wider than anyone had predicted, the way certain things do when the moment they describe has already been sitting in the air, waiting for someone to name it precisely. 2 satellite trucks were parked on the curb. Tommy Reeves arrived at 7:45 this time. He brought 2 co-workers, a woman named Priya who worked the morning valet shift at the Meridian Grand, and a man named Deshawn who had worked the garage the same night as the incident. Neither of them had said anything that night. Both of them had agreed without much discussion to come today. They sat together in the second row. The conduct complaint had been dismissed at 11:00 the previous evening. Fenwick had called Zara at 11:14. She had said thank you, set the phone down, and gone back to the brief she was reviewing. She had slept 4 hours. She did not look like a woman who had slept 4 hours. She walked into the courtroom at exactly 9 o'clock, a robe, straight, file-open, reading glasses on. The gallery was nearly full. She did not look at it. She looked at the file. Leonard Marsh was at the plaintiff's table. He looked like a man who had read Claire Ashby's piece and spent the night deciding it didn't matter. He had the particular composure of someone who had been in difficult rooms before and had always found a way out. Cassidy Vance sat beside him. She did not look at the gallery. She looked at the table. Marcus Holt was at the defense table. Ray Okafor sat directly behind him, the sealed envelope now open, its contents organized into 3 folders on the seat beside him. Dana Reyes sat next to Marcus, hands folded, still. Marcus called Ray Okafor to the stand at 9:22 a.m. Ray was sworn in, sat down, and stated his name, rank, and assignment with the brevity of someone who had testified before and understood that juries and judges responded to economy, not performance. Marcus walked him through 14 months in 35 minutes. The 9 contracts, the billing irregularities, the combined overbilling figure $11.4 million across 6 fiscal years, the campaign donation records connecting Councilman Paulson and Deputy Director Lyle to Vance Meridian entities in the same years the contracts were awarded, the access log showing Dana's entry into the infrastructure folder, the deletion log, the matching dates. He spoke in the flat, factual cadence of someone reporting measurements. No adjectives, no narrative flourishes, just numbers, dates, and documented relationships between them. Marsh objected 7 times. Zara overruled 5, sustained 2, both on narrow evidentiary grounds, with brief explanations that made clear the sustained objections changed nothing material about what had been established. When Marcus finished his direct examination, Marsh stood for cross. He worked methodically, questioning Ray's sourcing, challenging the relevance of the donation records, arguing that billing discrepancies in government contracts were common and did not imply intent. Ray answered each question with the same measured precision he had used on direct. He did not get frustrated. He did not get defensive. He waited for each question to finish completely before he began his answer every time without exception. After 20 minutes, Marsh tried a different approach. "Detective Okafor," he said, his voice shifting slightly, not aggressive, just pointed. "Isn't it true that you initiated contact with the plaintiff's attorney in this civil case while your criminal investigation was still ongoing? Isn't that a significant procedural irregularity?" Ray looked at him. "I shared publicly available financial records with Mr. Holt. City contracts are public record. Campaign finance filings are public record. I shared nothing from the active criminal investigation. But you facilitated a connection between a criminal inquiry and a civil proceeding. I had a cup of coffee with an attorney and showed him documents available on the city's public portal," Ray said. "Any citizen could have done the same." 1 or 2 people in the gallery made sounds that were not quite laughs, but were close. Marsh sat down. Marcus introduced the final exhibit at 10:48 a.m., a cooperation agreement, signed 2 days earlier by Councilman Derek Paulson, who had retained separate counsel and begun discussions with the U.S. Attorney's Office the morning after Richard Vance had called him and told him to make the problem disappear. Paulson had made a different calculation. The agreement detailed in Paulson's own words the arrangement between his office and Vance Meridian Group going back 6 years, the approved contracts, the coordinated billing, the donation routing, the phone call from Richard Vance 2 days ago asking him to have a federal judge removed from a docket. Zara read the cooperation agreement without expression. When she finished, she set it down and looked at Leonard Marsh. "Mr. Marsh," she said quietly, "does your client wish to make a statement?" Marsh leaned toward Cassidy. A brief whispered exchange. Cassidy's face did not change, but something behind her eyes did something that looked for the first time like the understanding that the room she was sitting in had stopped responding to the rules she had always used to navigate rooms. "No statement, Your Honor," Marsh said. Zara nodded once. She read the ruling aloud. 11 minutes. Dana Reyes, wrongful termination, documented racial harassment, retaliatory firing, awarded $1.2 million in compensatory and punitive damages. The financial fraud evidence referred in full to the U.S. Attorney's Office for Federal Prosecution. When she finished, she picked up the gavel. In the second row, Tommy Reeves was very still. Dana Reyes let out one quiet breath. The gavel came down. Richard Vance, who had been sitting in the back row of the gallery for the first time in the proceedings, stood up and walked toward the exit. No one stopped him. He just looked to the people who watched him go considerably smaller than he had looked when he walked in. The $1.2 million arrived in Dana Reyes's account on a Tuesday morning 6 weeks after the ruling. She was sitting at the small desk in her apartment in Decatur when the notification came through on her phone. She looked at the number for a long time. Then she set the phone face down on the desk and sat quietly for a few minutes the way you sit when something you fought for a long time finally arrives, and you need a moment to understand that it is real. She did not celebrate. She did not call anyone immediately. She opened her laptop and began drafting the business plan she had been writing in her head for 2 years. 6 months later, she opened a small consulting firm on Moreland Avenue, 3 rooms, 2 employees, a website that was functional, if not beautiful. The firm specialized in helping employees document workplace harassment and discrimination. The intake form on the website was 14 pages long and asked for dates, names, timestamps, and screenshots. Dana had designed it herself. In the first year, she took on 31 clients. The federal indictment of Richard Vance came down 8 weeks after the hearing. 14 counts. Contract fraud, conspiracy to commit fraud, obstruction of a federal investigation, and added in the final week of the grand jury proceeding, witness tampering, based on the phone call to Councilman Paulson asking him to have Zara removed from the docket. Richard Vance retained 4 attorneys. The legal fees in the first 3 months exceeded $900,000. Deputy Infrastructure Director Warren Lyle pleaded guilty to 3 counts and cooperated fully. Councilman Paulson, whose cooperation agreement was already in place, testified before the grand jury for 2 days. The Vance Meridian Tower on Peachtree Street remained open during the proceedings. The board of directors voted in a closed-door session 6 weeks after the indictment to begin transition planning. The company Richard Vance had built over 30 years began quietly and efficiently to restructure itself around his absence. Leonard Marsh's bar disciplinary hearing took place on a Wednesday afternoon in a room on the 2nd floor of the State Bar of Georgia building. The charge was unauthorized access and disclosure of confidential judicial records. The law school leak traced definitively to a device in his firm's possession. His attorney argued mitigating circumstances. The panel listened with the polite, unhurried attention of people who had already made up their minds. His license was suspended for 18 months. He left the building through a side entrance. Cassidy Vance was named in a second civil lawsuit 3 months after the first ruling. 2 former employees, one black, one Latina, filed jointly, represented by a law firm that had read Claire Ashby's piece and reached out the same afternoon it published. Cassidy called Leonard Marsh's office the morning the second suit was filed. His assistant told her he was no longer practicing. She retained new counsel at a firm that had not previously worked with her family. The attorney, a woman named Patricia Sue, met with Cassidy for 2 hours, and then called her own associate and said quietly in the hallway outside the conference room, "This is going to be a long case." Claire Ashby's piece, "The People Who Get Away With It," was published in a regional magazine and subsequently picked up by 2 national outlets. It won the Georgia Press Association Award for Investigative Journalism in the spring. At the awards dinner, Claire thanked her editor, her sources, and one unnamed valet who had, she said, shown up when it would have been easier not to. Tommy Reeves, watching the live stream on his phone during his break at the Meridian Grand, smiled at that. Judge Harold Fenwick retired 4 months after the ruling. His retirement letter to the court was 2 paragraphs. The second paragraph contained 1 sentence that was quoted in 3 legal publications. "The best decision I made in my final year on the bench was recognizing excellence when I saw it, and then getting out of its way." He did not mention Zara by name. He did not need to. Zara did not give interviews. She declined 2 podcast invitations, a profile request from a national magazine, and an invitation to speak at a law school symposium on judicial ethics. She sent each a polite, brief response and returned to her docket. She drove the Honda to work. She ate lunch at her desk. The dry cleaning tag was long gone, and the robe fit the way things fit when you have worn them enough times that they stop feeling like a costume and start feeling like a second skin. One Saturday morning in October, Sandra Mitchell came to the courthouse. It was early 7:30 a.m. The building nearly empty. The security guard at the front desk, a man named Gerald, who had worked the weekend shift for 11 years and greeted Zara every Saturday with the same nod and the same half cup of bad coffee from the break room. Zara walked Sandra up to the 4th floor and into courtroom 7C. The room was empty and quiet. The way large rooms are quiet on weekend mornings, a different kind of silence than when they are full, more honest, somehow stripped of performance and occasion. Sandra stood in the center of the gallery and looked up at the bench, at the seal on the wall, at the robe hanging on the hook beside the door. She stood there for a long time without speaking. Then she said, "Your granddaddy used to tell me, he used to say, the only rooms worth walking into are the ones that weren't built for you." Zara stood beside her and said nothing. "He would have stood on those steps outside for an hour," Sandra said, "just to look at it." "I know, Mama." Sandra reached over and took her daughter's hand. Her hand was small and warm and rough in the way that a lifetime of work makes hands rough, the hospital floors, the early mornings, the years of doing necessary things that no one photographed or applauded. They stood there together in the empty courtroom for a while. Then Zara walked Sandra back to the elevator, went to her office, hung up her coat, and opened the first file on her desk. There was work to do. There was always work to do. And Zara Mitchell, who had stood in a parking garage in a gray coat while someone called her homeless, who had read a conduct complaint at her kitchen table and gone back to her brief, who had cited case law from memory in a room full of people who had expected her to fail, simply did it. She never needed anyone to know who she was. She just needed them to feel it when she walked in.
Zara Mitchell was humiliated in a parking garage, threatened through back channels, and had her record leaked to discredit her before she ever picked up a gavel. At every turn, someone tried to reduce her to the coat she was wearing instead of the mind underneath it. She did not argue with them. She did not perform for them. She just kept working. Dignity is not something other people grant you. It is something you carry so consistently, so quietly, so completely, that eventually even the people who tried to take it from you are forced to sit in a room and watch it work. If this story reached something inside, you drop a comment. Tell me where you're watching from. Tell me who in your life carries themselves the way Zara did. Those people deserve to be named. And if you're not subscribed yet, this is the moment, because the next story is already waiting and it belongs to someone just like her.